Casa Chula Realty been in existence? Looks like about 6 years, something like that? Okay. And one way to analyze this would be to try to get a sense of the average income, given the real estate world, things go up and down, I'm sure. Would your client be able to give me, and I don't know if your client knows as well from joint tax returns, what the income has been for Mr. Lepe for the last 3 years? I guess we know 2017.
We actually had that average.
We actually
agreed
were
upon it.
discussing that.
Great minds think alike, okay.
So before we came in, we discussed that, and based on the numbers we went over, and we backed out some of the expenses that are duplicative, personal expenses, and for the combined income of Chula and the property management work that he does. In 2015, I had $61,888. That went up to $98,357 in 2016, and then in 2017 it went down to $81,591. And that average, when averaged out, it was $80,612, and divided by 12, that came to 6718, which was close enough to the number on the Disso Master that I had done. We just we sort of went with that for that possibility.
Okay, that seems fairly sensible. Ms. States, does your client agree that seems a sensible way to calculate it?
Yes, we do.
Yeah.
I mean, we could pick apart some of the details, but that's good enough for our purposes.
I think that seems sensible. All right, and then of course we've got the issue of the good night call, which I'm prepared to address.
Your Honor, could I be heard though on the support? The issue is that's money that was made in years past. I don't know that if we had somebody here who was a W-2 wage earner and their income had dropped for the last 10 to 12 months, which is this income dropped in 2017 and then in 2018 as well. I don't know if we would say, oh, well, that's tough, but we're gonna use the last 3 years of income to decide what your support's going to be. And the reason being is because once this court stamps its order, my client is under a possible motion for contempt of court. He has to have this court has to make a finding that my client has the ability to actually pay that money. And there's no evidence in front of this court that I'm aware of that demonstrates that. If anything, it's quite the contrary.
So are you suggesting that instead the court should order based upon his current income?
Yes.
And then when it goes up in 2 months, we gotta come back and do it over again?
No, I mean, if I wouldn't say in 2 months, but I would say if things get better progressively, then yes, that's the nature of support. It's if circumstances change. If we had made the support order a year ago, then my client would be in here today asking for a downward, and he'd be completely entitled to do that.
Certainly for a W-2 wage earner, that makes all the sense in the world. For someone who's self-employed, his income next month's not gonna be the same as it was last month, right? It's gonna change every month.
It is, but at least in this case, we have almost a year's worth of data to show his actual income. Not only that, but my client has maxed out credit cards just to get by. Any support, and that's without paying child support. That's just trying to get by, as both of these individuals are. I don't think there's enough money for either of them.
If I were to adopt your approach, then I would also order him to provide, more or less continuous updates to her so she can come back when there's an uptick.
He's fine with that. In fact, he came to the court today with all of his bank statements to show his income, and he's fine with continuing to provide all that data. He's not. There's no money being hidden anywhere. This is all that's come in. Again, like I said, if the court orders him to pay that, they're ordering him to pay it with money that he just
No, I understand what you're saying. I'll get to Ms. States in a moment. The reason why for a self-employed person averaging might make sense is because coming to court has its own costs. And so if I set it at what he's making this moment, and then we're back here in 2 months because he's making more, and we're back 2 months after that because he's making less, we're doing it all, they're gonna spend a lot of money on lawyers' fees that if we sort of picked average, and I understand that the past is not the future, but then it seems like we're gonna be recalibrating it fairly constantly, because he doesn't know, none of us knows what's gonna happen in the real estate market or interest rates, they seem to be going up, but maybe the Federal Reserve will change his mind, it'll go down again, and it's just gonna cost a lot of money to always recalibrate it. But you would your client would ask me to do that, even though that would mean, if I set it based on what it is now, and a month from now it's different, I'll reset it.
I don't know if it would be that extreme of a reset. I doubt we'd be coming to court every month on it, but every 6 months, sure. And preserving retroactivity if there was found income.
How much does it cost today for your client spent money today? I'm just worried they're gonna spend money coming to court to recalibrate it more than is even at issue. But let me hear from the states with her thoughts on whether I should set based upon what he's making, last week or some sort of average. Of course, I can't predict what he's gonna make next week because none of us really knows.
Well, the most important thing is to figure out what is the most likely income he's going to be making from this moment forward. And in order to do that, we need to look at an appropriate sample size. And that would, in my view, and in typical cases that I've read and been part of, it's been the last year of tax returns, like full year, because those are more reliable than interim partial years, which I may note.
Is there law endorsing that approach?
There's case law relating to one must look at the most appropriate sample size for that particular kind of industry. And that could be 12 months, it could be 3 years. And in this case, I think 3 years is a good marker because his income varies a little from year to year. And by capturing an average over the last 3 full years, we can get a pretty good idea of what the future will bring. What I can say for sure is that he's already acknowledged that he was not doing his best. My client reports that he actually intentionally stopped working because he was so angry. And only towards the last few months.
How does she know? Did he say that?
He said so. He threatened her. She'll never get a dime out of him for child support, spousal.
Okay.
And so, over his dead body, in fact, he's going to make it so she owes him. And so he's actually cultivated that arrangement that situation over the last 10 months. Since November, actually. It's almost a year since they've been in this high conflict situation.
Yeah.
So we've seen this major reduction in his income, which is not common in his industry. In fact, I know of no one who's doing badly.
Interest rates have gone up, there's no question.
Yeah, but realtors are still making a lot of money. So for him to suffer a 1/3 of his income all of a sudden is because he didn't work, either intentionally or because he couldn't. But now he's back to work by their own admission. He's now getting cases work again. He's closing escrows.
There was a time
so that last few months is not a good representation of what the future will bring.
Completely stopped working?
Yes, for about 6 months.
I'm not sure.
5 months?
Well, he said he was working. He didn't bring home any income from like late December through April. But he was always every day at the office and.
Well, counsel
Right.
indicated he was depressed and so he couldn't get out of bed. I
But
don't
not
know
that entire
what
time.
happened exactly, but we know that something was really off this last few months. But he's doing better now. So we'll see more traditional, more historical income recur now. So using this last little snapshot is not indicative of what we can expect to happen going forward. So for all those reasons, it's really important that
Maybe, and my crystal ball is no better than anyone else's. But
Your Honor, the case law indicates is that the court, as long as it comes up with a reasonable approach to determining what likely outcome, what the income is likely to be, it can do that. As long as that approach is based on data and is reasonable. But my client has had his market. The reason these interest rates have hit him hard is his average house price is around $400,000. Those are the home buyers right now that are really getting frozen out of the market. There's really not much of an option, especially with the interest rates going up. Yes, of course, if he was a Davis realtor selling $700,000, $800,000 homes, there's no sign any of that slowing right now. But he is a woodland realtor, and so things have slowed down.
Okay.
And yes, he was depressed for a few months at the beginning of the year. Also this average, this 2015, 2016, 2017 average doesn't include 2018, which I think would bring this down considerably.
Your Honor, I forgot to mention that his claim that his credit cards have been maxed out, we have proof that they've actually been paid down, not increased. So I don't know where that comes from. The records that I got today show for the one little snapshot I have for 1 month, he increased his last month's credit cards by $100. So it doesn't make sense.
Increase his balance by $100?
Right. So I'm not seeing what they're indicating.
My client
Also-
has his, what is it called, that app?
Credit Karma.
The Credit Karma, it shows his debt has skyrocketed, it's,
Isn't that what you just showed me?
but that's based on all the different credit cards that are,
He hasn't
yeah,
missed
out
a
there.
payment.
Well, she found something else. And the business records that we received for the last few months are the ones that I actually received in writing show a ridiculously small amount of money. I mean, we can't, that's like a teeny little snapshot and it's not, I don't have the opportunity to
Right.
verify any of this. And the other portions, the rest of the year, I don't know what they're reflecting on, but I haven't seen that. Or at least it's unreliable typically in the middle of a year. People typically get all their expenses and all their income pulled together for their tax returns, but up until then, it's kind of a mess. So I certainly don't think what they're postulating is most current is actually reliable information.
Most current income, or what you're talking about is expenses?
Profit and loss.
Profit and loss for the business.
I haven't even seen the
It's attached
latest
to the
one.
response to the article. As an example.
Not the INE.
Oh, and it's also, well, there's an updated one in the response, and it also attached to the INA.
Well, at any rate, middle year ones are typically not accurate.
This is
So-
not even middle, this is.
You're saying they're
10
not
months.
accurate because,
Data isn't all available. Generally
Right.
speaking, it's kind of a crapshoot what you have in your QuickBooks at any
Is-
given time.
does he ordinarily, when he's not in the middle of a divorce, generate a half-year profit and loss statement, or does he wait to the end of the year? Okay, you were just doing that because you can't do it for a year. Okay. All right, I'm gonna take about 5 minutes. I wanna run a number myself, I'll be back out. Ooh.
Thank you.
Thank you.
Dave, it was important that you both visit the same CPA in order that you can do the SEO and minimize taxes. But you're not interested in filing jointly as an, is what you're saying.
Why was it? But you said I have to.
Well, you don't have to file jointly, but you have to deal with the unreported income.
So I was gonna use a CPA.
That's not what I said, but
Oh, okay, just the same CPA.
yeah. Perhaps could have them advise you about, well, if you both stay separate, it's gonna be this amount. If you do a joint, it's gonna be this amount. And then you can decide whether you want to do that. Do you have any CPAs that you know that you trust?
Not really. He would handle that.
She's open to that.
Yeah, I'll give you some names. I'm worried about this whole like back and forth, like he goes to one, they do something, and then she goes to one and they do something. Then go to one that they both trust, then they can come up with a solution.
Oh, we need to mention that we've got this stuff.
Yes, I will, I'll do that.
So you don't want to print out that, you get a clean copy of
Yes.
that.
Yeah, awesome.
I know I shouldn't say anything, but I should, right?
I was just given this today, by the way, if you wanna look at it.
I mean, this is. That's pretty cool.
Any business accounts, what?
They're all personal, and it's like,
Okay.
I thought the buyers.
He says he has one with Chase, that he puts the money in for his rent, for the property management stuff. He pays the expenses out for the property management stuff.
That's all I'm.
So, yeah. But it's not a business account, it's still a personal. It's a
do I
personal.
have that one?
I have to look through, I'd have to go through the disclosures when I want to see, I mean, you should, right? In theory, if there's a bank account and his name's on it, you have it. So,
I don't know if I have all of these already handy, let me see what we.
You said I should know this, but you said that buyers pay for the vest. Or was that somebody else?
he's gonna go through it, the SAD, and if there's any account that's not in there,
Including real estate.
real estate accounts,
This is just my accounts, correct?
any accounts that there's money in there, that you have an interest in. And control, obviously.
Since we have a lot, you know.
Sure. I have Sudoku over here, I'm really invested in right now, but okay, what is it?
With regard to the partnership, I'm not really sure what the business relationship is between
Yeah,
broker and the client.
Yeah.
Clarify that.
he could you explain to her what the situation is with your business partner?
Yeah, I'm more like an office manager, and I get a, say referral for every agent I bring into the office, and every closing that I have. It's a sole proprietor, I'm not on the document, it's just kind of like, we agree with this since he started the company and I joined him when I left Remax, type of deal. So there's nothing,
You both are completely separate, he 1099s you. or
yes,
something?
correct.
I told you I spoke to them.
You smell cool, doesn't is he?
He says he's not.
Yes.
How do you know that? Because he's saying he's not. And the tax returns say he's not.
Unless he always lied to me. His business cards say go.
Right? Was that just for marketing?
Probably, just.
Just because it sounded good.
Somebody co-owns it.
Yeah, well, that's because the plan was when I get my broker's license, and I would be the part owner. But I don't have my broker's license, so I'm just a real estate agent. So when the time comes I get my broker's license, then maybe then that would be, it wouldn't be a sole ownership anymore, it would be more like a partnership in writings.
But right now you have no ownership interest in that entity.
Just whatever agent I bring into the office, and then whenever they have a closing, I get like a referral for that person.
Remain seated, come to order, Superior Court Department 3 is now on.
That's a lie.
So first, let me start out by expressing my appreciation for the parties and the lawyers for taking the time today. It's nice to meet you. I think from all indications, you're good parents and you'll get through this process okay. Let me start off with custody issues. I will be adopting the mediator's report with one modification. I will grant parents to have joint legal and physical custody of the children. Parents will utilize the current plan, which is a 2-2-3. With respect to the disputed issue, I understand Mr. Lepe's position, but in my view, for children of this age, a short good night call would be beneficial. It shouldn't be seen as an intrusion upon the other parent, but just a chance to touch base with the children. I think the children probably enjoy it from both parents. I'm going to put some parameters around it, however. I will allow the call every night, but it shall not exceed 5 minutes. So it'll just be a short, how was your day? Mommy or daddy loves you, good night sort of call. And I'm going to set a specific time. It's going to be 7:45 p.m. so you know exactly when it's going to happen. I will adopt the holiday schedule the parties have put forth. I will adopt paragraph 13, no derogatory remarks about the other parent. Turning to support, the parties have a situation where mother receives income at a fairly steady rate. She's a W-2 earner, and her income is fairly straightforward. Father is the owner of a business in the real estate market, which is subject to fluctuations, and his income has fluctuated based upon market, based upon other factors, I'm sure, as well. For anyone who works on a commission, there are a lot of variables that determine how much is being made. It has been urged that I should use a 3-year average based upon the theory that his income will go up and down. That's a more reliable indication of what his income will be going forward. In my view, that's not an appropriate benchmark given the fact that his earnings are highly dependent upon market conditions, and market conditions don't necessarily move in 3-year cycles. You can have 5-6 years of a down market, a few years of an up market. It's really anyone's guess. Also, the court is mindful of the fact that he has to actually pay this amount, and so he can't pay it based upon future earnings or past earnings. However, it is true, I believe, that his earnings for the last few months have been depressed because he has been preoccupied perhaps with the family law situation. That's understandable, but hopefully going forward his income will be higher. And also, there are other factors that may have made his income a bit lower than it normally would be. Taking those factors into account, the method I've selected to use is to take the most previous income, which was calculated about $4,200, I believe, and add a 20% increase on the theory, again, that it's been depressed because of his preoccupation with the case and other matters, and that this would be a reliable, or the court's best guess as to what, or estimate as to what's happening going forward. That results in wages, imputed wages to him, in the amount of $4,807. Plugging those numbers into the Dissomaster with her income at $5,004, we result in a $15 payment from her to him for child support. He's waiving child support, so there would be a 0 child support payment, and it results in a no spousal support payment. So I will not be ordering support at this time. However, I do agree with Ms. States that the numbers at the end of the year are going to be most reliable. So I will ask the parties to revisit this issue after the 2018 profit and loss statements are available, and to file, if necessary, further RFOs to modify this. I would entertain retroactive modification, potentially, depending on what the numbers show. So we'll see where we're at the end of 2018, and if it's significantly different, the court may make a different order. But for now, I'm not ordering any support.
Your Honor, may we have an order that he use best efforts to become
Yes,
fully?
I will make that order explicit. And don't take this as an insult in any way, but it's something that the court would always order, especially for a self-employed person. You are to make best efforts to maximize your income. You've obviously got a reason to do this, more money in your pocket, and obviously better for your children too, to have more resources for their support. So that will be part of my order.
And Your Honor, we have we actually asked for custody. We did make some modifications, and they're all agreed to here, along with the mediator's recommendation is being modified.
Would you be willing to prepare an order after hearing based upon that?
That just includes all of this?
Yes,
I can do that, yeah.
or I can take what you have there. as well.
Okay.
Let's see what the changes are.
Your Honor,
Are they on a holiday schedule?
The holiday schedule is included in there. There was just some changes we made in terms of,
Okay,
and we also, there's a property order in there, and there's
okay,
also.
well, I'll need to sign this then. I'll need to add in the call, because that's not in here probably.
Yes, well, that's part of your order, but we could,
Well, okay, that's fine. We'll just deal with it separately. We'll have the order for the call.
yes,
And-
and I can do that
So
order.
if we can prove that he's lying, then we can get a retro order.
Okay. All right, so I will sign this stipulation, which includes the parties' agreements.
Continue
Ms.
to-
Bates?
You can take it.
He was gonna date, so now he knows for how long he has to place your rates. So he'll continue to do what he's doing now until he leaves. Yeah, he will. And then when you guys have this there, then you're your house. Yeah.
Were there further questions?
oh, I just wanted to make sure I understood that there's retroactive modification possible.
Potentially.
If we can prove that he's not being forthcoming here today.
Yes, I'm reserving jurisdiction to do so. So, the parties have full discovery rights if necessary. If there's suspicions along those fronts, you have full right to pursue that.
Thank you.
Very good. I've signed the stipulation. Mr. Packpour will prepare the order after hearing, which will simply add in the good night calls that I've ordered. Very good. Again, nice to meet you folks. Look forward to seeing you.
Appreciate your help.
Thank you.